¿Qué tal, comunidad? Aquí habla su abogado Ray Ibarra Maldonado. Hoy es jueves 29 de junio y vamos a estar hablando de una decisión nueva de Corte Suprema, qué significa y qué cambios vamos a ver en la administración de Biden y también cómo puede afectar el caso de DACA. Voy a empezar en inglés, después voy a ir a español. Ladies and gentlemen, happy Thursday, June 29th. Last week, a very important Supreme Court decision came out. Was super anxious to see it for two reasons. One, for what it means for that actual case, and it was about the immigration enforcement and what Biden can and cannot do and who he can and cannot pursue for removal. And two, how it's going to affect the DACA case. So I'm super excited the decision came out, and even more excited that it came out in our favor, but not totally overjoyed because it could have been a little bit better. There was a hint there of negativity, which I'll go into in just a minute. So thanks everybody, and as always, ahorita estoy empezando en inglés, pero si tienen preguntas en español, puede ponerlo ahí. Whatever language you feel most comfortable putting your question down in, go for it. And here's what we're going to do today. We're going to start with that immigration enforcement, but I also want to do a shameless plug, right? Shameless plug for us having a brand new video out. If you have not seen it yet, please go over either to my page, to YouTube, wherever you want to, but it's just a super awesome video that we're very proud of. Features our office, the team, what we're about. It's long, I know it's long, 3 minutes and a half or something like that, but it really tells our story better than we've had any video tell the story before. So we're going to do a little bit of fun stuff with it starting on Friday. I'm just going to, make sure you tune in on Friday. We'll announce some fun stuff, maybe some kind of prizes or something to go along with it. But check it out and then come back on Friday. We'll go over that part as well. All right. So that's that. And then getting into the nuts and bolts. Remember, we go straight to the source here, right? So you go to supremecourt.gov. That's going to take you to this page right here where you have all the decisions. You go to opinions, click on it, and you come down, and then you can get the decisions. We have one that we're not talking about today, but this is a heartbreaker that came out today on affirmative action. We're focusing on today is United States v. Texas. And that case was decided, and let me give you a little bit of background on that before we go into the actual decision. So every administration, for as long as I can remember, sets their priorities for enforcement removal. Obama had his, Trump had his, Biden created his. And to be quite honest with you, I was in favor of them. It's hard for me to say I was in favor of any enforcement. It just seems unnatural for me to say out of my mouth. But compared to Trump, compared to Obama, I liked the guidelines that Biden put out for ICE. Now, that didn't last very long because Texas and Louisiana filed a lawsuit saying that they don't like the lack of enforcement as they're seeing it, and that there's two laws particularly that say that the president shall or the executive shall detain somebody upon release from incarceration, and therefore President Biden was violating those laws. And the district court in Texas agreed with them and said, you're right, Biden administration, you cannot input this removal priorities that you have. You must continue to remove more people, basically. That was appealed to the Fifth Circuit Court of Appeals. The Court of Appeals said the same thing. They agreed with the district court. That was appealed to the U.S. Supreme Court. There was oral arguments on that. The court decided previously 5-4 to not overturn the lower court's ruling. So we've been in pause ever since the decision came out from the district court. The pause is going to be undone now because the U.S. Supreme Court has issued their ruling last week stating Texas and Louisiana, the two states that filed the suit, they do not have standing to challenge the decisions by the president of who to focus on for removal. So it didn't get to the merits of the actual case, the argument that President Biden was violating these two statutes by not enforcing it the way Congress intended to. The Supreme Court said, hey, hold on, we're not even going to go there. Why? Because states cannot just randomly sue the federal government for executive decisions having to do with civil enforcement. and having to do with prosecution. They wanted to say that that is in charge of whoever wins the presidency, and they have the ability to do what they want to do without every state challenging that process in federal court. Now, states can still go out and ask Congress or ask, for a new legislation to be passed, but they cannot go into a federal courtroom and say, order the president to stop doing what he wants to do. So therefore, we get back the enforcement priorities. Now, before I get to that, what might that mean for DACA? The strongest argument we have in preserving DACA is the same argument that this case the administration won on, which is the standing. Same state, Texas, but a few other states are saying they do have standing to challenge. They do have the right to go into federal court and ask a judge to rule that DACA is unlawful because they are in some way hurt. Now here, I was very excited to read the decision. Let's get it back up here again. Because I was looking for, well, what does that mean in terms of the DACA case? So here we have part of the decision here, and I wanted to point out, fourth, a challenge to an executive branch policy that involves both the arrest or prosecution priorities and the provision of legal benefits or legal status could lead to a different standing analysis. So that's a quick one-sentence little jab in there that says, Attorney Ray, Abogado Ray, chill out, right? Just because we're saying it in this case doesn't mean for the DACA case we're going to say the same thing. And they're pretty much relying on that prong there, saying, hey, in this case, there's the promise to not be removing certain people, but there's no promise of work permit. Where with the DACA program, there's a promise not to be removed, plus the benefit of a work permit. So for that reason, I think this case, you still have to go through the reasoning, the analysis, but I think the Supreme Court, is giving an opportunity for the DACA case to continue on the merits based on the fact that they also get work permits versus just the enforcement priorities. All right? So now you might be asking yourself, well, what is that? What does it mean? Okay, maybe it's not the best for DACA. There's a little jab in there against us. But now who are the priorities? What does it revert back to? So we go here. This is the original memo that was released. And check it out what it says up top. I thought this was interesting. This is still on the ICE webpage. Hasn't been taken off. And here you have this little box up here that says on June 10, 2022, U.S. District Court of Texas issued a final judgment vacating this memorandum, and accordingly, until further notice, ICE will not apply or rely upon what we call the Mayorkas memorandum in any manner because of that case. So now this language has to come off, right? They have to go in there and take this little stamp out, delete, and republish and put it back up here on the webpage, back from September 30th of 2021. And the first pages here, they were anticipating a lawsuit, so they're going over, this is how our legal authority is to do this, and this is what the Supreme Court has said before about the discretion that we have in enforcement. So I think they probably still would have won on the merits if they would have gotten to it, but nonetheless, they lost because of standing. So here are what the enforcement priorities should be as of the day after the Supreme Court decision, reverting back to that. Who should be the enforcement priorities? A, anyone who's a threat to national security. So we're talking anybody that has engaged in or suspected of terrorism or espionage. Those individuals should be the priority. And this is the Biden administration saying, hey, and they say it in the pages above, we recognize there's roughly 11 million people here undocumented. We do not have enough resources to go after every single person. So these are the people that we're going to focus on. And it's coming from up top to educate those down at 2035 North Central and other local ICE officers of who they should be focusing on for removal, as well as the trial attorneys who are in charge of the cases, as well as the Court of Appeals attorneys. Everybody within the system should now be paying attention to this memo again. Section B is the broad, where really anybody can be swept up into it, but at the same time, it gives opportunity for us to argue pretty much for anybody that's in removal proceedings or possibly going to be put in removal proceedings. So what they say here is a non-citizen who poses a current threat to public safety, typically because of serious criminal conduct, is a priority for apprehension and removal. Now, in the past, you would see the words like aggravated felony, crime of violence, domestic violence, certain crimes that were bright line rules. If they were in that category, you were a priority for removal. Here it's a very broad, where they do go over some factors, right? If we're going to see something that would lean towards the being an enforcement priority, the gravity of the offense and the sentence imposed, the degree of harm caused by the offense, the use of sophistication, use of a firearm or weapon, or a serious prior criminal record. So these are the things that when we're writing to ICE, we're going to put in the memo there, kind of bullet point, bullet point, bullet point, how those who are lucky enough to serve do not fit within this category. And then the good thing here is they also go over some mitigating factors, right? Hey, maybe, the person is elderly, great grandma with the court hearing coming up and shouldn't be removed. You might also be hearing more about that in the near future. Young, they've been here a long time, mental condition, they've been a victim of a crime. All these different factors that we can use to say, hey, you know what? Yeah, they do have a criminal history or criminal conviction, but because of these reasons, they shouldn't be a priority to be removed. And then, so again, it goes over here like, hey, this is the totality of the circumstances. Everybody should look at it, each case individually, so we can determine whether or not the person is a priority. And then the last one, the one I disagree with the most, which kind of goes in the face of A and B, is this word threat to border security. What does that mean, threat to border security? Oh, you're a threat to border security if you were apprehended after November 1, 2020. Okay, makes no sense to me. Sounds completely illogical to say threat to border security. But what they really mean is recent entrance, right? Someone that came across recently within the last 3 years. So those individuals that came across in the last 3 years are in the same category as terrorists and the same category as threats to public safety. Those are the three categories of human beings that should be the enforcement priority for ICE, according to this memorandum. Now, it's still early. We're still like barely even a week out from the decision, so haven't heard a lot of rumblings about how it is starting to be used or enforced. Usually these things take a while to roll out. Like on this one, I think it says at the bottom, another 60 days that they'll start it because they have to train and educate their own staff and everybody. But this is what we're looking at right now. This is the result of the Supreme Court decision that we had last week. All right. Questions, comments, concerns, throw them down below. I'm going to switch over to Espanol in just a minute here. But if you have any questions, comments, or concerns, even in English or whatever language you speak or write in, please drop it down now, and happy to address it. And remember, as always, if it's personal stuff, feel free to just DM me and or give us a call, give us a text here at the number below, 602-910-4040. Right? So, now to Espanol. Okay? Muchas gracias todos por esperar tanto tiempo. Nita says this is good news for DACA, right? It does give that argument still a chance for us to say the standing. Muchas gracias a todos por estar aquí hoy. Voy a estar revisando un caso nuevo de Corte Suprema que, como está diciendo Anita aquí, es buenas noticias para DACA. Voy a empezar con eso porque sí es importante. La decisión de DACA vamos a esperar probablemente este verano. Yo creo que en los siguientes 2 meses vamos a recibir una decisión del juez Hannon en Texas sobre DACA. Y el argumento más fuerte que yo pienso las personas como Amales, los abogados, tienen es el tema legal de standing. ¿Qué significa eso? Eso significa que nada más hay ciertos grupos de personas que tienen derecho de ir a Corte Federal y poner demanda diciendo que quiere que el Corte dé un orden. Eso es jurisdicción del Corte, y para que una persona mete una demanda y presentar la demanda en frente del Corte, el Corte primero tiene que determinar si la persona o el grupo tienen lo que se llama standing, el poder de poner la demanda. Eso es porque nada más queremos que personas que fueron dañados directamente tienen recurso a los cortes. Estamos protegiendo la dignidad del corte para estar seguro que la persona que quiere la demanda es la persona que fue dañado. Aquí, en el caso de Texas que vimos la semana pasada, el Corte Suprema dijo bien claro, Texas, Louisiana, los dos estados que pusieron la demanda, ustedes no tienen standing. Ustedes no fue dañado personalmente y ustedes no pueden poner demanda diciendo que el presidente no debe o debe hacer algo en la área de buscando cierto grupo de personas o no buscando cierto grupo de personas para deportaciones. Entonces no llegaron al argumento legal que ellos pusieron diciendo que hay dos leyes que significa que el gobierno tiene que arrestar personas después de ciertas convicciones en la cárcel o salir del cárcel o prisión, pero significa que el Corte Suprema dijo no, ustedes los dos estados no tienen derecho a poner ese tipo de demanda, entonces vamos a tirar el caso y regresa los mismos categorías de prioridad para deportación que Biden anunció cuando él empezó a ser presidente. ¿Y qué son esos grupos de personas que va a estar enfocando el presidente? Aquí tenemos, vamos a ponerla aquí arriba, hay 3 categorías que ya debe ser el enfoque del presidente de ICE, ¿verdad? ICE está ya ordenado a enfocar y ojalá ellos siguen las palabras de este memorándum del año de 2021, perdón. En A estamos hablando de cómo ellos van a revisar y educar. Si es algo que nada más tiene una semana, a lo mejor no están listos ya migración para seguir eso, pero nosotros ya, obvio, estamos usando eso para el beneficio de las personas que estamos sirviendo. Y las primeras personas que va a estar enfocando el ICE, por las palabras del presidente y el señor Mayorkas, son personas que son un riesgo a seguridad nacional. Esas personas que están aquí para hacer terrorismo, ellos son prioridad número 1 para ser arrestado y deportado. Categoría B aquí es una categoría mucho más grande, donde ellos van a poner la mayoría de las personas que siguen intentando deportar. Y no es algo bien claro que este tipo de convicción, por ejemplo, en el pasado era felonía agravado, crimen de violencia, crimen de abuso de niños, esos son una categoría que siempre lo enfoca el gobierno, drogas de venta, ¿verdad? Aquí no están diciendo nada de eso claro. Lo están diciendo, mira, tenemos que analizar cada caso y cada convicción, si había armas, si no había armas, si había riesgo en la comunidad, o si era algo que pasó hace mucho tiempo, y dar la oportunidad a los abogados y las personas que están representando las personas en proceso de deportación, de poner un argumento a ICE diciendo, mira, por esas razones, por su edad, porque era joven o ya es mayor, por su presencia, los años que tiene en Estados Unidos, por problemas mentales o servicio en el ejército de ellos o su familia en el pasado, son razones por que debe parar la deportación. Siempre va a intentar ICE a arrestar gente y deportarlos porque es su trabajo. Ellos existen para hacer eso. No es como ellos aquí están diciendo que ICE no debe hacer su trabajo. Están diciendo que debe enfocar en personas que son un riesgo al público. Hay 11 millones de personas aquí sin permiso. Lo que debe estar enfocando ICE, por las palabras del que está encargado de aprender seguridad nacional Mayorkas, son personas que son un riesgo a la comunidad. No es nada. Si dice, mira, si uso armas, si es una razón para pensar que son un riesgo al público, pero no es nada que es garantizado que debe resultar en deportación si tiene esos tipos de cargos. También un factor aquí, si la convicción fue vacated or expunged, que significa si hay cargos en el pasado, una cosa que los abogados deben estar haciendo ya es mandando esas peticiones to vacate o to expunge al corte penal para que podamos también presentar eso a ICE diciendo, mira, el corte que ya puso los cargos antes ya lo está diciendo que lo van a tirar el caso o lo van a dar beneficios a la persona en futuro que no debe perjudicar mucho el caso ya. Eso es otra cosa que debemos estar enfocando mucho a alguien que tiene una historia penal. ¿Okay? Y la última categoría que ellos tienen aquí son las personas que apenas entró después del 1 de noviembre 2020. Esas son las tres categorías: terrorismo, riesgo al público por convicciones, y C, que entraron después del 1 de noviembre 2020. Si no están en una de esas tres categorías, basado en las palabras de ICE, ellos no deben deportar. No deben intentar seguir poniendo a la persona en su país de origen. Vamos a ver si ICE va a seguir esas palabras, ¿verdad? Porque las palabras pueden venir de arriba, pero si las personas que están en posiciones de poder, porque yo sí tengo clientes que son abuelas que lo están diciendo, oh, su cliente es un riesgo al público por algo que ellos hicieron hace 30 años. Palabras buenas aquí, pero seguimos peleando bien duro contra ICE para estar seguro que ellos siguen esas palabras y no deportan personas. Ojalá tenemos éxito con eso. Cualquier pregunta, comentario que tiene, por favor ponga aquí abajo. Con mucho gusto puedo intentar contestar. Si no, voy a terminar el video. Y recuerdo que mañana puede ver nuestra página otra vez, porque vamos a tener un anuncio muy importante, que usted pueda ganar algo de todo lo que voy a decir. Me dijeron, abogado, no debes decir lo que estamos haciendo. Le dije, ok, no voy a decir, y doy mi promesa que hasta mañana no voy a decir nada. Pero mañana nos vemos en nuestra página para hablar más del video que hicimos, que ojalá usted tenga chance de ver, y cómo usted puede ganar algo. Es todo lo que puedo decir. ¿Okay? Aquí nos vemos mañana. Que tienen excelente día, comunidad. Nos vemos.